Hello, and welcome to Counseling Ethics, Lecture 12. My name is Dr. Amber Hughes. In this lecture, I want to talk about confidentiality. Confidentiality is something I'm pretty sure you're all aware of, and I'm pretty sure you all know how it fits into the counseling profession, but I do want to start with some basic definitions here to make sure we're all on the same page. So first, what is privacy? Privacy is the right of persons to decide what information about themselves will be shared with or withheld from others. So privacy really lies with the clients. It's their right to determine what they share. Confidentiality, on the other hand, is an ethical concept, referring to the counselor's obligation to respect the client's privacy and to the counselor's promise to clients that the information they reveal during counseling will be protected from disclosure without their consent. Confidentiality lies within the counseling relationship, and it's an ethical obligation. Privileged communication, on the other hand, is a legal concept. It protects clients from having confidential communications with their counselors disclosed in a court of law without their permission. All right, so privacy is a concept that really lies with the client or the person. Confidentiality is an ethical concept, and privilege is a legal concept. We're going to focus on confidentiality in this lecture. We'll talk about privileged communication in the next lecture. Helping professionals assume that an assurance of confidentiality is an indispensable requirement for effective therapy. Without this assurance, helping professionals assume that clients will not feel safe to discuss the intimate personal aspects of their lives or seek counseling. This is why we work so hard to guarantee and ensure confidentiality with our clients. However, research shows mixed empirical support for the effect that assured confidentiality has on open client disclosure in therapy. Honestly, I understand and I certainly uphold confidentiality with my clients. However, having worked in an alternative school with adolescents who have very little rights to confidentiality, they have parents and guardians who have access to information. We had, parole officers and probation officers, and they're the same thing, right? Social workers. They just were in the system, and so they had a lot of people who had the ability to find out information. And it never seemed to affect our relationship, though. That lack of confidentiality, and knowing that there were certainly exceptions to confidentiality, they still shared a lot of information. So I get that. I get that mixed support. I understand the importance of it, and I certainly value it. However, I do think that I don't think you should be turned off by some of the things we're going to be talking about next in terms of confidentiality in groups and confidentiality with minors. I think that you can still have that relationship even though confidentiality isn't guaranteed. Confidentiality and privacy has an entire section devoted to it in the ACA Code of Ethics. This is Section B. It emphasizes the client's right to privacy in the counseling relationship. However, confidentiality is not absolute. There are times when counselors must breach confidentiality. For example, Standard B1D says that counselors must inform clients at the outset that there are limitations to their confidentiality, and this conversation falls under informed consent, which we've already talked about. And we will talk specifically about exceptions to confidentiality in an upcoming lecture, Lecture 14 actually. Now, there are a couple of special considerations with confidentiality that I want to touch on. First, counseling multiple people, like group counseling or family counseling. Generally, when your client and one or more additional persons are in the room, confidentiality is compromised and privilege usually is waived. You can make your own pledge not to disclose certain information. You can guarantee that you will keep confidentiality. However, you cannot guarantee that others, such as group participants or family members, are going to maintain confidentiality. So you cannot guarantee confidentiality in group, couples, or family counseling. Again, this is a conversation you want to have during the informed consent process so that people can choose what to share and what not. So it's their right to privacy. They don't have to share everything in these situations if they understand that confidentiality is not guaranteed. It is difficult to enforce confidentiality in these settings, and group members are not bound by the same professional standards, so they don't have to follow any ethical codes or laws to maintain confidentiality. These group members don't. We ask them, we talk about the importance of confidentiality, we talk about respect and those things whenever we do group counseling, but we cannot guarantee confidentiality. Confidentiality also cannot be guaranteed in couples or family counseling. This can especially be an issue when dealing with family secrets or like divorce proceedings that may involve one spouse wanting information disclosed and the other not. So it can certainly be a complicated issue in any time you're working with multiple clients, but definitely when you're working with family counseling. Finally, confidentiality is an issue when counseling minors, like I mentioned before. When clients are minor children or legally incompetent counselors, we cannot give the same assurances of confidentiality as we give other clients. Minors and adults who have been adjudicated incompetent in a court of law do not have a legal right to enter into contracts. Therefore, their parents or guardians control their legal rights. And this also applies sometimes whenever someone has been mandated to go to counseling. If the client is like the judge or whoever, or the court maybe, whoever is forced this person to go to counseling, sometimes the contract is with the court or the judge, and so it's kind of the same situation. We have a right to share information with that individual. This can become a major conflict for counselors who are striving to protect their clients' rights to privacy, but still owe legal duties to the parents or guardians as well. So how do you handle situations like this? Well, first with informed consent. That's super important, and we'll talk about it constantly through this class. If you give people information ahead of time, it allows them to make decisions whether or not they're going to share information. Okay? So with informed consent to the minor or adult, and a conversation with guardians or parents or whoever has the legal right to the information. And with some parents, and I'm going to talk about minors in particular because that's where my experience lies. With some parents, this usually, it may not even be an issue. Though you still want to have the conversation with them, they may not, they may not try to get information, they may not be interested in the information, and so it may not be a huge issue with some parents. Other ways you can handle it are by making sure that parents understand the value of maintaining confidentiality and the role it has in the counseling process. And again, whenever we talk about informed consent, this is a process. So if you get a phone call from a parent, you can remind them, you can have this conversation with them again. And if parents still want to know information, you can ask them to allow you to talk to their client, who is their child, first before you break confidentiality. Hey, this is really, it's really important that I keep confidentiality. I understand you want the information, but can I talk to your child first so that it doesn't harm the relationship? Because that's really first and foremost in my mind, and then I'll tell you. You can also ask to moderate a conversation so that it's not you breaking confidentiality, but maybe the child talking to the parent. These are just some examples of how you might negotiate this or how it might go down. It doesn't typically look like you just spilling the beans to the parent after every session. All right, some takeaways. Confidentiality is important, but not always guaranteed. In Lecture 14, we'll look at exceptions to confidentiality.